Citizens United, the Supreme Court had reaffirmed the fundamental right of every individual to engage in open discussion about the qualifications of candidates for public office. But beyond the federal Constitution, of course, the Wyoming Constitution also protects a similar right. Fundamentally, campaign finance reform relates to core constitutional values that are held in Wyoming. Whether like-minded neighbors, civic organizations, for-profit corporations, Wyoming residents often associate freely and share their views on all sorts of topics. When it comes to elections and the political process, those rights should also be protected. In the wake of Citizens United, there's been a campaign of some fear and speculation about the impact that corporations might play on the electoral process. But the concerns mask a fear that is really much deeper, and that's a fear of more speech. To be clear, more speech is nothing to fear. Unleashing free speech and association is what James Madison described as the solution to the problem of factions in Federalist 51. In examining the nature of a free society, Madison asked whether it was better to curb the role of factions entirely or whether to allow them to compete freely. And so the simple idea was that corporations would battle against unions, doctors against lawyers and the like, and by giving full vetting to those ideas, you would have a healthy exchange and the best policy at the end of the day. Today, we see factions in the role of corporations, special interests, nonprofits, think tanks, trade associations, and the like. There's nothing inherently suspect or foul about them, other than the fact that they are groups of people assembled together for a common purpose. I want to move on to what the Supreme Court held in Citizens United. January 21st, 2010, the Supreme Court issued its opinion. This was a rare case because it took the court about 2 years to issue its opinion. There was initial briefing and oral argument scheduled, and the court did not reach its decision in the initial term. It asked for supplemental briefing to read as a fundamental precepts of the First Amendment. At issue was whether government could ban corporate speech related to candidates for public office in the days leading up to an election. And in the strong affirmation of the First Amendment, the court held that government was prohibited from doing exactly that. The facts about Citizens United need to be touched on briefly because they're often forgotten in a lot of the fear of corporate speech and what this means for electoral reform. Citizens United was a nonprofit corporation, a group of citizens who came together, who wanted to run advertisements and a documentary film about then presidential challenger Hillary Clinton called Hillary the Movie. But under elements of the Federal Election Campaign Act, the Bipartisan Campaign Reform Act, otherwise known as McCain-Feingold, they were prohibited from doing so in 60 to 90 days before the primary elections. The question then is if the members of Citizens United had spoken freely. Federal election law at the time provided the possibility of severe fines or even criminalization for their speech. At this point, Wyoming should look to embrace the liberty and heralding effect of Citizens United. And this is a republic where the people are sovereign and the ability of the citizenry to make informed choices among candidates for office is essential. That's the Supreme Court. The sorts of discussions about the qualifications of candidates for office are integral to the operation of the system of government established by our Constitution. Fortunately, the First Amendment and the Wyoming Constitution guarantee that all speakers will be protected under the rule of law, bringing the focus of this presentation to Wyoming's current legal landscape.